Hi everyone, welcome to Horror Newspaper Analysis. This is a video for the 16th of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. First up, in the editorial segment is an Indian Express article. Now this article is an important one and I'll tell you why. See here, the Supreme Court has set a precedent, so to say, because the court has termed illegal the arrest of a person on the ground that the due process which is required to be followed in arresting a person, those were not followed here. So, for example, the person was not, made aware of the grounds for which he was arrested, and a couple of other irregularities, very important and very huge irregularities, were involved in this particular case, and as a result, the arrest was termed as illegal. Now, who is this person? What is the case against him? That is going to be the center of discussion in this article. Let's start with the title of it. So it is Failure to Follow Procedure, why Supreme Court said Newsclick founder's arrest was illegal. Now this is going to be followed by the second segment of news updates, where we discuss news updates in the national and international categories. And this is going to be followed by the last segment of legal news, where today we just have one update to cover. So without further ado, let's start and let's have a look at this article title first. Failure to follow procedure, why Supreme Court said Newsclick founder's arrest was illegal. Now let's quickly have a look at the context and then we get into the technicalities of this topic. So invalidating his arrest in a terror case, the Supreme Court has ordered the release of Newsclick founder editor. His name is Prabir Purkayastha. Prabir Purkayastha, he is the founder editor of Newsclick. He was arrested last year, and now the Supreme Court has termed his arrest as illegal and hence has ordered his release. The reason that the court gave for this particular, order of the court, it is that the Delhi police failed to inform this person concerned, Purkayastha, the ground of his arrest before taking him into custody. The ruling by a bench, which is led by Honorable Justice B.R. Gavai, it is significant because it emphasizes that proper procedure and due process, these are the guardrails against arbitrary action, even in stringent terror cases. Now, please remember, this was a case wherein the stringent provisions of the UAPA, which is the Unlawful Activities Prevention Act, those were invoked here. So the case against this person was very grave. Still, the Supreme Court said that this arrest, it is illegal. Why? Because the fundamental tenets of Indian Constitution, they've been very blatantly violated here. And what is that? Article 22 of the Indian Constitution, which categorically provides that a person should be informed about the grounds of his arrest. So that was blatantly violated. And as a result, his arrest is illegal, regardless of the fact that the case against him, it is very stringent, it is very grave. Now let's talk about the issue of timing of his arrest, and in essence, let's have a look at the case which was against this person. Purkayastha, he was arrested at about 6:30 in the morning of 3rd of October last year by the special cell of Delhi police. So he was arrested in the early hours of morning on 3rd of October last year. Invoking the Unlawful Activities Prevention Act, the Delhi police alleged that Newsclick, the web portal or news portal of which he is the founder editor, it received money for pro-China propaganda. So the case against him was that he received money for furthering the pro-China propaganda and therefore UAPA was invoked against him. The FIR, it roped in a couple of provisions of the UAPA along with IPC. So if we have a look at UAPA, the sections are section 13, which provides for unlawful activities, followed by section 16, which talks about terror activities, 17, which provides for raising funds for terrorist acts, followed by 18, which talks about conspiracy, and section 22C, which provides for offenses by companies and trusts. Apart from that, IPC section 153A, which provides for promoting enmity between different groups, along with section 120B, which provides for criminal conspiracy, they were also brought in picture here. So please understand, Purkayastha's case is that on 4th of October, which is the next year of his arrest, next day, Next day of his arrest, without any prior notice, he was taken to the residence of a special judge at the same time, which is nearly 6:30 a.m. in the morning, for his remand. Now, just to give you a very brief undertone to the criminal procedure here, this is what happens usually, that when a person is arrested, within 24 hours, you have to seek the remand orders from the magistrate concerned, because otherwise the further detention of the person is illegal. So in order to keep the person detained beyond a period of 24 hours from his arrest, you need to get the permission of the magistrate concerned and have a special order in this regard. So in order to secure his police remand, the police presented him without prior notice, before the special judge the very next day in the morning early hours itself. Now, his lawyer claimed that on their client's insistence, at around 7 a.m., they were informed about the proceedings over a call. In proceedings before the Delhi High Court, Purkayastha said that an unsigned copy of the remand application, it was sent by WhatsApp to his lawyers without mentioning the time of his arrest or the grounds of his arrest. So this is a very, very huge lapse on part of the police personnel concerned here in following the due process of law and in following the procedure which is provided in the criminal law and also under the fundamental law of our land, which is the Constitution of India. However, even as objections to the remand, they were filed before 8 a.m., his lawyers were told that the remand order had already been passed and 7 days of police custody had already been granted to the police. Crucially, official records show that the remand order was signed at 6 a.m. Now, please note this time. As per the official records, his remand order was signed at 6 a.m. when we know that he was presented before the magistrate concerned at his residence at 6:30 a.m. So this is anti-time, this particular application order, which is even before his production before the judge or his lawyer were informed. So even the FIR in this particular case, it was made public only after a few days had passed after his arrest. Purkayastha's case essentially was this. So this was the conclusion of his case, the contention of his case, that his arrest was illegal because it was not followed with due process. Now, in this respect, it is important for us to understand the provisions of Article 22, especially Clause 1 of Article 22 of the Indian Constitution. So what does it provide is, it says that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So there are two safeguards that we can spot under Article 22, Clause 1. One is that you have to inform the arrested person of the grounds for his arrest. Secondly, he must be given an opportunity to be defended by an advocate of his own choice. Now, significantly, on 3rd of October, when he was arrested, the same day on which Purkayastha was arrested, Supreme Court gave certain direction in another case. So this is also very important. What is the name of that case? It is Pankaj Bansal versus Union of India. So what did the Supreme Court hold on that day? The Supreme Court held that to give the true meaning to constitutional statutory mandates, by statutory, because a replication of Article 22, it can be found in, let's say, our CR.P.C or any other laws which create provisions for arrest. So it would be necessary, the court held, henceforth, that a copy of such written grounds of arrest, it is furnished to the arrested person as a matter of course and without exception. So the very same day when he was arrested, the Supreme Court in another case held that it is important henceforth from now on that a copy of the written grounds of the arrest should be furnished to the arrested person without exception and as a matter of routine, as a matter of course. While Pankaj Bansal, it was regarding a money laundering case and the provisions of the PMLA, which is the Prevention of Money Laundering Act, were invoked. The UAPA 2 contains similar provisions which require the grounds of arrest to be presented. So since both of these cases, these laws, the UAPA and the PMLA, they are comparable, therefore the ruling would be deemed to be applicable to UAPA as well. Now see this technicality. of being informed of the ground of arrest. Why does it become so important? Okay, we understand it is a constitutional mandate, it is a fundamental right. It is in fact, a very, very innate right that a person has by virtue of the very fact that you're a human. So it has an undertone of being a human right as well. But why this technicality becomes all the more important in legislations, let's say like PMLA or UAP. So the reason, please note, is because in these special statutes, which are very stringent in themselves, and often they are titled as draconian statutes also, there are the right to get bail, it is very, very difficult. So therefore, once a person is arrested, getting bail becomes very difficult. Therefore, it is important to make sure, to ensure that all the procedure, the due process and formalities of law in making the arrest of the person, they are absolutely followed and complied with. Now let's talk about Delhi Police's version in the Delhi High Court. How did the Delhi Police justify its lack of following the procedure before the Delhi High Court when the matter was before the Delhi High Court? So here, Solicitor General Tushar Mehta, he voiced the opinion, he represented the Delhi Police, so to say, the stance of Delhi Police, and he said that before the Delhi High Court, he stated that the offences which were alleged against Purkayasta, they are very serious and as such ought not to be interfered with by the High Court on technical grounds. He had invoked India's national security concerns, the stability and integrity of the country, and he cited email exchanges between Purkayasta and other entities, which indicated that there was a deliberate attempt to show the state of Jammu and Kashmir, now the Union Territory of Jammu and Kashmir, and the state of Arunachal Pradesh as disputed territories. So much so that the words used for Arunachal in the particular mail, these are northern border of India, which in according to the learned Solicitor General, it is generally used as a Chinese propaganda. This was noted by the Delhi High Court. So essentially what we gather from this entire discussion is that this is a very important ruling or response of the Supreme Court. Why? Because here the Supreme Court, on a technical ground, so to say, has held the arrest of this person as illegal in a UAPA matter, which is a very stringent law in itself. Why? Because the lapse in securing the arrest, it is of a huge extent, because we know to be informed of the ground of your arrest, it is a fundamental right under Article 22, Clause 1, to be particular, of the Indian Constitution. So therefore, it is very important that these formalities, these procedural courses, they are followed with and they are not flouted by these agencies like the police. And with this, we proceed to the national news updates, this being the first update here. So this update, it is in continuation of an update that we did a couple of days back, where we noticed that there is a shift of who is going to handle the security of our parliament now. We've seen that in the recent past few months, there was a breach of parliamentary security. And as a result, concerns regarding the security of the parliament complex and the parliamentarians, it was, it came to the forefront. So as a result, the security is now being handed over to the CISF, which is the Central Industrial Security Force. So this is an update in the continuation of that. CISF, it lists out phased takeover of Parliament security. The security checking at the gates of the Parliament, dog squads, vehicular access control, pass sections, and all required security arrangements, they have now been taken over by the Central Industrial Security Force. You may make a note of this agency who has now taken up the security force. IndiaSkills competition commences. The four-day nation's biggest skill competition, which is called the IndiaSkills 2024, it commenced in New Delhi yesterday, which is on 15th of May. Let's talk about this particular program. What is this competition about? So India Skill Competition, it is aimed to demonstrate the highest standards of skilling and offers a platform to youth who want to come forward and showcase their talent at the national and international levels. Now, how do they do it? So the bright students from these competitions, they will be selected and provided further training by industry experts to represent India in the World Skill Competition, which is the venue of which is France, and it is scheduled in September this year. So both these competitions, they are placed in such a manner that once the national level competition has commenced, it is concluded, then those who have gotten, let's say, good ranks, then they are sent, trained and sent at the world level competition to represent India. Tata AIG launches India's first insurance for space tech sector. The Indian general insurer Tata AIG, it has unveiled a satellite in orbit third-party liability insurance policy. This new insurance product claims to be India's first. It is designed to provide critical financial protection for satellite manufacturers and operators. So this is a first of its kind, and it is provided for space tech sector. What does it do? It is designed to provide critical financial protection to those who are involved in satellite manufacturing and its operation. It is designed to offer comprehensive coverage for third-party bodily injury and property damage in the event of an incident involving an orbiting satellite. Next up is an update in the sports category, and this is also an important one. Ace women's table tennis player Manika Batra. Please make a note of the name of the player. She rose to a career best singles ranking of 24 following her success in Saudi Smash. Now, what is the title that she secured? As in, why 24th ranking is considered to be very important? Because she has become the first Indian woman paddler to break into the top 25 in the world ranking. She is at the 24th ranking. Google Arts and Culture launches Millets Seeds of Change exhibition. Google Arts and Culture and India's Ministry of Agriculture, both of these entities, they've collaborated for what? For an exhibition which is called Millets Seeds for Change. This exhibition, it dwells into the journey of millets, showcasing their evolution from ancient staples to contemporary superfoods, and emphasizes their nutrition value, their role in climate resilience, and potential to address global food security challenges. AIIMS New Delhi, it has entered into and signed an MOU with University of Bolton Institute of Medicine, UK. The All India Institute of Medical Sciences, New Delhi, AIIMS Delhi, it has signed a memorandum of understanding with UK-based university, which is the Bolton Institute of Medicine. It's marking the start of an international partnership to work collaboratively across several areas, including medical research, innovation, and education for undergraduate and postgraduate education. Now, this has brought us to the international segment for today, where first update is from Singapore. Singapore's new Prime Minister, Lawrence Wong, he makes a speech after being sworn. So, a new Prime Minister for Singapore has taken the position, and please note, he has become the fourth leader ever since its independence. He's the fourth leader. China overtakes US as India's largest trading partner in financial year 24. According to data released by Global Trade Research Initiative, an economic think tank, China has emerged as India's largest trading partner for the fiscal year 2023-2024. It surpassed the United States. The two-way commerce between India and China stood at a staggering $118.4 billion, slightly edging out the $118.3 billion trade, which was done with US. So now the biggest trading partner that India has in this respect is China. And this is for the financial year 2023-2024. Now, this has brought us to the legal segment for today, where today we have a very important update. This is with respect to Cr.P.C. See, the Supreme Court essentially has held that in order for the convict to pay compensation to the victim, it would not result in the reduction of the sentence which is imposed on the convict. So let's say the convict has been, sentenced to 3 years of jail term or imprisonment, so to say, and he has also been ordered under Section 357 to pay certain compensation amount to the victim. So then, would that amount would that be would that be equivalent to the fact that since the court has directed the accused to pay compensation to the victim, so therefore there'll be reduction in his sentence? The answer here is no. These two are independent orders. So the court observed that in criminal proceedings, the court should not conflate sentence with compensation to the victim. Sentences such as imprisonment and or fine, that is to say, whether it is imprisonment and or fine, these are imposed independently of any victim compensation, and thus these two stand on a completely different footing. Either of them cannot vary the other. These two are independent. Let's talk about Section 357. So 357 of the CRPC, it provides the power to award compensation to victims of the offense out of the sentence or fine imposed on the accused. It empowers the court concerned to award compensation to the victims while passing judgment of conviction. In addition to conviction, the court may order the accused to pay some amount by way of compensation to the victim who has suffered by action of the accused. The name of this particular matter is Rajendra Bhagwanji Umrania versus State of Gujarat. So with this, we come to an end of our TNA. Thank you so much for being with us. Have a wonderful day ahead.